Hey, it's your girl, your favorite paralegal, and welcome to LegalDoc Talk 24/7. Hope you guys are having an awesome day. All right, so this is in response to a comment on the last, I have to say, Tony Buzbee Jay-Z video that I did yesterday. And so I won't misquote. One of the individuals asked me if can Busby be disbarred for this. The answer is no. And I'm going to get in regards to the rules of civil procedure, specifically rule number 11. But before I do that, I do want to read part of the letter that I read yesterday that Jay Z's attorney filed late last night. And it reads so pretty much there's two things that are going on here. One, they're saying that the complaint is frivolous. None of the allegations in that complaint is factual. And then there's a second part. The second part, what they're saying is that Busby is not admitted to practice law in the state of New York. Therefore, he is in violation of Rule 11. And because he is in violation, they are asking for sanctions. And so I'm going to explain the sanctions part, but we know that the young lady came out and to NBC News, and she stated pretty much her account of things. Of course, the father did not know. I don't even think he even asked her, what happened, where you been, or any of that. So of course he's not going to say anything, or he's going to deny allegations because she probably never told him. But the most important thing I want to address is Busby going to be disbarred? And I'm going to read the rules of civil procedures because in order to be disbarred from something, you have to actually do things, you have to have repeated violations. And another thing is that it will be up to the jurisdiction to see if somebody will get disbarred or even suspension. And so the judge in this particular case is Judge Torres. So in the event there is a motion for sanctions, then that motion for sanctions will actually be determined by her since she is the federal trial judge. I'm not sure if there's a magistrate judge on there, but if there is, I don't think that the motion will be heard before the magistrate judge, only because they only assist the judge in a federal proceeding. But let's get into the letter. And like I said, I went over this yesterday, so you're more than happy to watch that previous video to get my full intake on the letter as a whole. But I'm just addressing the disbarment phase. So it says, in light of those developments, it is not clear that Mr. Busby signed the complaints and other filings in the case in violation of Federal Rule of Civil Procedure 11. Under that rule, an attorney who signs a document assumes an affirmative duty to conduct a reasonable inquiry into the facts and the law before filing. They have cited Business Guides Inc. and Chromatic Enters Inc. And Title 498 of the U.S. 533, 551, 1991. It then states that the attorney's signature denotes merit in a filing and sends a message to the district court that this document is to be taken seriously. They also cited New Alliance Party versus the FBI, where they stated that the plaintiffs must not file a complaint in this court without having made a reasonable investigation of the facts. In addition, attorneys who learn after filing a complaint that factual assertions are false must immediately withdraw claims. They cited City of Yonkers versus Otis Elevator, stating that a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous. They also cited Two Farmer Connect LLC versus Mission Pharmaco Company, where they stated that imposing Rule 11 sanctions for amended complaint that repeated allegation that lacked evidentiary support. Now, this letter came after the NBC News broadcast. So it says, given today's revelation, Mr. Buzbee almost certainly failed to undertake a reasonable inquiry into the facts before filing the complaint. He should never have brought the claims. Fox and Brochure states that affirming sanctions order where plaintiff's complaint was entirely frivolous and was made as part of a conscious effort to harass the defendant. At minimum, he should withdraw them now. Allowing these claims to remain pending even a moment longer not only harms Mr. Carter, his family, his businesses, his employees, his legacy, it also impairs the integrity of the judicial system, thwarts the pursuit of justice, and silences the voice of the true victims. Furthermore, it appears that Mr. Buzbee has attempted to circumvent the authority of this court to enforce Rule 11 and associated obligations by declining to seek admission to this court before signing pleadings and other documents. So they're not only asking for sanctions for him filing a frivolous complaint, but they also are asking for sanctions in actually practicing law in the state of New York without even having admission to do so. So it goes on to say that Mr. Buzbee is not licensed to practice law in this court, and he has not sought, let alone obtained, admission for pro hoc vice. Yet in the nearly 8 weeks since he initiated this proceeding, Mr. Buzbee has filed a complaint in this matter that was signed solely by him using, and that's the court stamp signature. It's /S. Signed the amended complaint alongside other counsel that added Mr. Carter as the defendant and noticed the motion for the plaintiff to proceed anonymously, accompanied by a supporting brief and a declaration, once again signed only by him. Most recently, on December 10th, 2024, Mr. Buzbee filed a letter which he also signed alone. And then it says Mr. Busby's failure to obtain admission in the bar of this state is transparent attempt to circumvent the basic requirements of Rule 11 and the rules of professional conduct. So it's really unethical for him to be practicing law in another state that he does not have a license, and that's the reason for a pro hoc vice. Pro hoc vice application is an admission, and the judge, so in this case, misjudged, the Honorable Judge Torres will actually review. And if everything is completed, regardless of, how can I say this? So you submit the application, you submit the fees, and then they review. If everything is good, then they'll go ahead and grant it. If they if everything is not good, or they find a reason as to why the attorney should not be admitted in that jurisdiction, then they will decline it. All right. Let me see. All right, so admission subjects an attorney to the jurisdiction of the court and to sanctions for signing pleadings that are not grounded in the facts and the law. Mr. Busbee thus appears to have strategically declined to seek admission in order to avoid sanctions for a complaint that he knew had no factual basis. Given these facts, Mr. Carter intends to file immediately a motion to strike the First Amendment complaint under Rules 11C2 and 12F, and it says that he respectfully requests that the court shorten the filing deadline for that motion from 21 days to 1 day from the date of service in light of today's stunning public disclosures and the severe ongoing harm to Mr. Carter's reputation. So it does give us the rules, the Federal Rules of Civil Procedure 11C2. So that is what they are referring. So I am going to go ahead and pull up the rules. All right, so here on the screen we see is the Federal Rules of Civil Procedure, Rule 11, and this is in regards to signing pleadings, motions, and other papers, representation to the courts, and sanctions. So once again, to the young lady who asked the question, no, he cannot get disbarred. The only way he would get disbarred is if he made repeated, rigorous violations to Rule 11. And even though somebody will submit, and I say somebody, if the other party or the other counsel will submit some type of motion to the court to even have that, it's still going to be up to the Honorable Judge Torres to see if suspension or disbarment is needed. Otherwise, the main thing, if you violate Rule 11, the federal Rule 11, then you will be subject to sanctions. And sanctions is just the attorney paying attorney fees to the other party or counsel. That's how that works. So if he gets sanctioned, he would have to pay attorney fees to the other party. In this case, to Jay-Z. All right. So going over this, mind you, the letter said C, but I'm going to go through all of this so you guys can understand it, because it does go coincide with what we just read. So, Rule 11. So, for signatures, Part A, every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresented. The paper must state the signer's address, email address, telephone number. Unless a rule or statute specifically states otherwise, a pleading need not be verified or accompanied by an affidavit. The court must strike an undersigned paper unless the omission is promptly corrected after being called to the attorney's or party's attention. So, Jay-Z in the letter asked, not asked, they are wanting to do, now I didn't see anything on the docket where they filed a motion to strike, but they wanted to strike the amended pleading for the simple fact Tony Buzbee is signing these pleadings and he's not even represented in that jurisdiction, or he's not admitted in that jurisdiction. So now let's look at Part B, Paragraph B, where it talks about representations to the court. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances. It is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. The claims, defenses, and other legal contentions are warranted by existing law or by non frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. The factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on belief or lack of information. So this goes to the frivolous amended complaint that was filed to add about to say Sean Combs, Sean Carter, aka Jay Z. So they're saying that these are false claims. There is no evidence that proves that Jay Z done it. Okay, so what they're saying is Busby not only violated section or paragraph B by filing a frivolous complaint, but he also is not even admitted in the freaking jurisdiction. And they're not even, they gave him from not 21 days, but 1 day to correct the situation, meaning that he would have to file a pro hoc vice application with the jurisdiction so that way he could be in compliance. But I don't think that he did it because I just checked the docket and I didn't see any updates. So we still got some time. Right now it's 7:29 on the East Coast. So I'm gonna keep checking to see if he does this. Now, what happens? Because now he has violated the signature part and he has violated the B part. So both paragraphs A and B. So here are the consequences, which is called sanctions. So C, and then I think let me go back. It says C, Federal Rules C2. So C2 is what he stated in his letter. But I'm going to read the whole thing and then you guys can understand what sanctions are. So, in general, If after notice and a reasonable opportunity to respond, the court determines that Rule 11B has been violated, the court may impose an appropriate sanction on an attorney, law firm, or party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its partner, associate, or employee. This is, the filing of the frivolous amended complaint. All right. Now, talk about, let's see. So the F2. So it states motion for sanctions. A motion for sanctions must be made separately from any other motion and must describe the specific conduct that alleges violates Rule 11B. The motion must be served under Rule 5, but it must not be filed or be presented to the court if the challenge paper, claim, defense, contention, or denial is withdrawn or appropriately corrected within 21 days after service or within another time the court sets. If warranted, the court may award to the prevailing party the reasonable expenses, including attorney fees incurred for the motion. So, what they're saying is that, all right, first of all, they have to file a motion for sanctions. I don't even see a motion for sanctions that has been filed. Now, they put it in a letter, but they didn't file an actual motion for sanctions. And I could go on there. Let me see. I'll do that later on. I'll do that, and I might have to update you guys. But I did not see a motion for sanctions that was requested. I just see this letter, and this is a letter. It's not a motion because it doesn't even have the case style on there. Yep, this is just a simple letter. So a motion for sanctions will have to be filed, and they have to describe specifically, what was violated. Now, if it goes before the judge can use this as a motion and she can rule on it. So it's just up to Judge Torres on what they plan to do with this. 3, it says on the court's initiative on its own, the court may order an attorney, law firm, or party to show cause why conduct specifically described in the order has not been violated. Rule 11B. 4 says nature of a sanction. A sanction imposed under this rule must be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. The sanction may include non monetary directives in order to pay a penalty to the court, or if imposed on motion and warranted for effective deterrence, an order directing payment to the movement of the party, which would be the other party, or all of the reasonable attorney fees and other expenses directly resulting from the violation. Let's see. Then it says limitations on monetary sanctions. The court must not impose a monetary sanction against a represented party for violating Rule 11B2 or on its own unless it issued the show cause order under Rule 11C3 before a voluntary dismissal or settlement of the claims that made by or against the party that is or whose attorney are to be sanctioned. Requirements of the order. An order imposing a sanction must describe the sanctioned conduct and explain the basis for the sanction. And then we don't have to get into discovery because, oh yeah, it's just saying that it does not. So this Rule 11, does not apply to discovery. So all in all, if a motion for sanctions was filed, the consequences would be non-monetary directives or order to pay a penalty to the court or a motion and warranted for effective deterrence, an order directing payment to the other party for part or all of the reasonable attorney fees and other expenses directly resulting from this violation. So if let's say that the judge say, okay, you have to pay if saying that Tony Buzbee has to pay sanctions and he has to pay attorney fees, then he would be responsible for whatever attorney fees that Jay-Z had to put out for, fighting this case, this claim, this amended complaint that was filed. All right. So doesn't talk about suspension. It doesn't talk about disbarment. It only talks about sanctions. All right. So to the young lady who asked that question, no, he would have to repeat this time and time and time and time and time and time and time again. But it would be up to the judge to say, hey, okay, we need to now talk about suspension or disbarment because you're not following Rule 11. So he's not going to be disbarred. The most he will get is sanctions. Now, here's the thing. How can he correct this? He could correct this by actually filing a pro hoc vice application to the district. Now, if it will be approved, I don't know, because that is going to be up to Judge Torres to determine, because we see that Jay-Z lawyer is saying, okay, everything that's being, stated in these allegations are frivolous. They're not, this doesn't have any factual basis. They don't have anything to support the claims. Um, and then on top of that, the judge also sees that Buzbee hasn't filed a pro hoc vice application. So when he does, she is going to take that into consideration. But you or I don't know how she will rule on that application. Who? So, man, when I tell you this is actually getting juicy, it's getting juicy. Every time I root for Buzbee, he's lacking. So I don't know if somebody in that Buzbee firm is about to get in trouble because they didn't submit the application. Because, like I said, I personally haven't been on situations because I know how to handle my dockets. But from working at previous firms, and I have had the pleasure, nah, I don't want to say the pleasure, let me back. I have had the opportunity to witness people get chewed out because they forgot to file the application on behalf of the attorney. Like, that is one thing. So I don't know if Tony just, because he's a national trial attorney. So he's going to have people up under him that does all this. The only thing he probably got to do is just show up for court. Okay, I'm gonna tell y'all right now, we have a signature and we just put it on, be like, hey, is this good? Can we add your signature? If so, then we're shooting it out. So he's not, once again, behind the desk sitting there drafting all of these um, pleadings, right? He is just showing up in court, approving, filings, so on and so forth. So I'm thinking somebody forgot to file the application and they probably getting cussed out, but who knows? But so I hope this answered the young lady's question. To sum it up, no, he won't get disbarred. The only way that he can get disbarred or even suspension if it was a repeated violation of the Rule 11. He has not done this. This is the first instance that we're coming out. The only thing that they're talking about is, the frivolous complaint as well as him not being admitted in the New York District Court. That's it. It's not a repeated violation of Rule 11. So the only thing that can happen to Tony Buzbee is he be sanctioned. And we have gone over what it means to be sanctioned and how they can be sanctioned. All right. So y'all tell me about how y'all think he's gonna get sanctioned. Do y'all think he's gonna be paying Jay-Z's attorney fees and all the costs associated for fighting back on these claims? Y'all let me know in the comments below. Don't forget to like, share, and subscribe. Until then, y'all be blessed and I'm out. Bye.